Hey everybody, welcome back to the Court of Random Opinion. My name is Lauren Neidigh. So we've seen obviously a lot of news in Justin Baldoni Blake Lively over the last few days. A lot of it I haven't been able to be here for because I was on the 15-hour flight back from Australia, and then I'm now in LA. As you know, LA is a little crazy right now. I was actually staying downtown initially, and I woke up to like some really loud helicopters and sirens and just all kinds of stuff. So I'm actually now I'm out in Burbank and it's a little bit better, but things have been just like a little crazy for me over the last couple of days. So I haven't been able to be around much. But I do have a couple of these things that I want to go through. The first one is the judge's endorsement from this morning on Blake Lively's question of can she show evidence of garden variety emotional distress versus the medical evidence, which is now precluded because she did end up agreeing to dismiss her emotional distress claims with prejudice. And then we also have Wayfairer's response to Blake Lively's trying to compel their communications with content creators, reporters, etc. So we'll go over that too. Give me 1 second. What I meant to do. Obviously, the internet has been an unkind place over the last couple of days. I think you guys probably know. Um, anytime there's a big ruling or something in Blake's favor, I get some unkind characters coming my way, a lot of them. But the overwhelming consensus among those people is that I'm a fat pig, and they like to tell me that. So it's been a rough couple of days for me as far as like socials and stuff like that. But I've been trying to just stick to what I'm doing in my life and away from the computer. But I do have to kind of get back to work. So yeah, so that's been pretty rough. But essentially that's going to happen every time something goes in her favor. So I'm sure I'll get more of that this morning, but I'm just kind of trying to let it die down. It's inevitable. So yeah. Sorry, I hope that fan isn't too loud, but I actually don't know how to turn it off. I did try. So okay. Let me pull this up. Okay. So here's his note here. It says the ruling at docket 206 that if claims are not dismissed, the court will preclude Lively from offering any evidence of emotional distress, referred to medical evidence of emotional distress. The ruling did not preclude Lively from offering evidence of garden variety emotional distress. So she still can't present evidence from like doctors or therapists or whatever. And if you ask me, I don't think that she had any, which is why they don't really care about that. I don't think there was any. Sorry, that's my opinion. I know lots of people aren't going to like me saying that. Most of them are people from Twitter, but I don't really care about you, so that's fine. Anyways, we can read this letter from her attorneys where they were asking the judge if she's allowed to do this, just to explain a little bit more about what this means. Let's see. By that order, the court denied the motion to compel information regarding the identity and treatment records of Miss Lively's healthcare providers related to emotional distress, as well as a HIPAA waiver. So this is where they, Wayfairer was trying to compel these things. The judge said, no, you guys need to work it out. But if she does decide to bring forth her claims of like intentional infliction of emotional distress and negligent infliction of emotional distress, she will not be allowed to provide any medical evidence. So Ms. Lively and the Wayfarer parties have agreed in principle to dismiss the 10th and 11th causes of action with prejudice. Ms. Lively, however, seeks clarification regarding the court's notation in the June 3rd order that Ms. Lively would be precluded from offering any evidence of emotional distress if the claims are not dismissed. This leaves open a potential question about what evidence may be presented if the claims are dismissed. Ms. Lively respectfully requests clarification from the court on that point before signing a stipulation to dismiss the 10th and 11th causes of action with prejudice. By dismissing these causes of action, Ms. Lively is agreeing to forego the presentation of evidence of treatment by healthcare providers or diagnoses for any psychiatric disorder to preserve the psychotherapist's patient privilege. Again, they say that, but I just think there isn't any. I don't think there's any evidence to present. So this is a well-established right that a plaintiff may exercise in order to protect highly confidential and private physical and emotional health information while still preserving the right to pursue those emotional distress damages that are recognized as inherent in claims for workplace sexual harassment and retaliation. So this here can be a little confusing because they're not saying like Blake Lively has these records and she doesn't want to produce them, right? It's worded in such a way that might make it sound like that, and there might make it sound like she wants to protect that confidentiality. But if you really read it carefully, you can tell, it doesn't necessarily mean that there is any evidence of such. They're just speaking generically about this issue. So, like I said, I really don't think there's anything to present. I think that's the problem. So, okay. Where do we get to here? By dismissing the standalone claims for intentional and negligent infliction of emotional distress, Ms. Lively will waive the right to offer testimony or evidence of the identity, records, treatment, or diagnoses of her healthcare providers related to such emotional distress, which was the subject of the discovery the Wayfairer parties sought to compel, as the court recognized in the June 3rd order. Consistent with the law and the draft stipulation for dismissal presented by the Wayfairer parties, however, Ms. Lively's choice to dismiss is intended to be without the withdrawal or dismissal of any other claim, counterclaim, or third-party claim asserted therein. Thus, Ms. Lively is not abandoning emotional distress damages generally and continues to pursue damages for emotional distress that have been recognized as inherent in workplace harassment and retaliation, often referred to as garden variety emotional distress, as contrasted with claims such as intentional or negligent infliction of emotional distress that a defendant's actions resulted in a specific psychiatric disorder. In other words, garden variety claims are those which allege that a claimant was scared, embarrassed, shamed, or humiliated, as opposed to actions seeking recovery for serious psychological injury, that is, the inducement or aggravation of a diagnosable dysfunction or equivalent injury. So here's my thought on that. She's had, I think, what was it, like a body double? One of the body doubles from the film come out and say, like, she was acting different, or she was not acting the same. And she'll probably have a couple people like that come in and say, oh yeah, she totally seemed distressed. The thing is, like, you can't prove that Justin Baldoni is the reason that she felt distressed. So they can definitely question that. Also, she's an actress. Sorry to say it, but she's an actress. I would not be surprised if she was kind of acting scared or embarrassed at some point after the fact, when she was trying to get him cut out of the promotion of the film, if she was acting like she was somehow embarrassed, scared, or humiliated, just to kind of bolster her support there and explain to people why he shouldn't be involved with them in promoting the film. I know people aren't going to like me saying that, but that's how I feel about it. Okay. In cases where the emotional distress damages are garden variety, the plaintiff may still present her own testimony and testimony of percipient witnesses who observed her emotional distress without providing medical corroboration. This includes testimony that the plaintiff suffered humiliation, anxiety, stress, embarrassment, loss of sleep, loss of appetite, etc. Accordingly, Ms. Lively seeks clarification from the court that, should she sign the stipulation for dismissal with prejudice prepared by the Wayfairer parties, the court shall not preclude her from presenting testimony and evidence of garden variety emotional distress damages on that basis, including testimony of herself and percipient corroborating witnesses, and the Wayfairer parties shall likewise not be precluded from conducting discovery on those topics, and that the scope of her waiver is as to offering testimony or evidence of the identity, records, treatment, or diagnoses of her healthcare providers related to such emotional distress. And the judge is saying, yes, that's correct. Like, she can offer evidence of such. And the Wayfairer parties can do discovery in this area, which means they can try to prove that her emotional distress or whatever else she's claiming, not emotional distress, but her like embarrassment, shame, fear, blah, 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 was related to other issues or was not caused by sexual harassment in the workplace, or was disingenuous. So, all right. Here's the other thing I want to go over, which is Wayfairer's response to Blake Lively telling the judge, like, you need to get them to tell us what their communications were with certain reporters, content creators, whatever. Respectfully, we are brought before the court solely because the Lively parties served interrogatories that were not consistent with federal rules of civil procedure and have been unwilling to bring them into compliance. Even though the Wayfairer parties served their valid responses and objections to the interrogatories on April 18th, The lively parties waited 3 weeks until May 9th to challenge those responses and objections and to seek to meet and confer. After a telephonic meet and confer on May 13th and an email on May 16th from the lively parties council purporting to memorialize the parties' positions, the Wayfarer parties substantively responded a few business days later on May 21st. The lively parties then waited until May 30th, 9 days later, to respond. In that May 30th email, the lively parties unilaterally demanded that the Wayfarer parties supplement their responses to certain interrogatories by June 6th. The Wayfarer parties assured the lively parties that supplemental responses would be forthcoming on June 13th. Instead of waiting until June 13th, the lively parties filed a motion. Identification of email accounts provided by the Wayfarer parties to third parties. And remember, Blake Lively's team is kind of accusing Justin Baldoni's team of doing this weird, Al-Qaeda-like process of like sharing information with content creators in order to smear her. So they would like put them in a draft folder, share it, and then remove it somehow. Even though these days you can tell who accessed these shared folders, even if it's not, if they're not opening the document, if they're not downloading the document, you can still see who accessed these things. So they can see who opened it. And you can see when something was placed, you can see something when something is deleted. So I just don't think that there's some crazy like conspiracy like thing going on here. But that's what Blake Lively's team is kind of alleging is going on between the Wayfarer parties and certain content creators and reporters. Which is fucking crazy. But all right. The first interrogatory at issue, which the lively parties acknowledged was ambiguous, asked the Wayfarer parties to identify any email account from May 1st, 2024 to date, in which any third party, including but not limited to content creators or the media, had access for the purpose of communicating information of any kind, including messages, talking points, guidelines, scripts, or other information regarding Miss Lively, Mr. Reynolds, the digital campaign, the CRD complaint, or the actions. At the heart of our good faith attempts to meet and confer is the lively party's failure to adequately define access in the context of a non-existent untraceable smear campaign, a concept which is unfamiliar to us and importantly appears to be unfamiliar to the lively parties who have been unable to clearly articulate what they are seeking. Although they did give 2 examples, providing login credentials was their suggestion, not ours, their catch-all language recreated ambiguity. 1 second here, guys. All right. Without citation to any evidence, or even specifying the factual basis for their allegations, the lively parties allege that they believe that the Wayfarer parties have engaged in covert tactics to communicate with third parties in a manner to avoid leaving a paper trail, such as by placing information in a draft folder or other email repository and providing a third party with viewing access to the folder or email, which enables the third party to view the information without leaving a digital trace. For the avoidance of doubt, the Wayfarer parties have never engaged in such alleged clandestine communications. Lively has indicated a deficiency in the response of only one of the Wayfarer parties, the agency group or TAG. TAG will substantively respond to this interrogatory by June 13th, thereby mooting the portion of the motion. Okay. Identification of media outlets. Let's see. The second interrogatory issue, which the lively parties acknowledged were overbroad, now asks the Wayfarer parties to identify all reporters and news or media outlets of any kind with whom you have communicated in any manner concerning Miss Lively, Mr. Reynolds, the CRD complaint, the actions, or the Lively Reynolds companies from June 15th to the present. Imagine if the Lively Reynolds companies had to produce their information, you know what I mean? Because there's this whole issue of the Van Zandt thing that still has not been really addressed. Why is the judge allowing a garden variety of lies? That's it. I mean, it's a good question, but the way that you put that is really funny. Lauren, I was just getting caught up at the beginning of your video. I'm bi and told my husband he should worry about my crush on you. Just remember that when the unkind folks are bullying you. Well, thank you very much for the compliment. But you know, I don't want your husband to be worrying about anything. But thank you. I appreciate it. Okay. You're in my city. Sorry, we set it on fire just before you arrived. Yeah, yeah, it's a little crazy around here. Okay, anyways. Federal Rule of Civil Procedure 26B1 provides that parties may obtain discovery regarding any non-privileged matter that is relevant to any party's claim or defense. As memorialized by the parties' emails, the lively parties improperly refused to limit the scope of this interrogatory to communications concerning the claims and defenses in this action. In the form proposed by the lively parties, a response to the interrogatory will broadly capture, for example, any reporter or media outlet with whom the Wayfarer parties communicated it as part of any promotion of the film It Ends With Us, because Blake Lively is the co-star of the film. I mean, that makes sense to me. So, oh, sorry, my sister's texting me. Okay. The lively parties do not explain how the identities of the media outlets through whom some of the Wayfarer parties promoted the film or communications concerning Lively and Reynolds in general is relevant to Blake Lively's claims or the Wayfarer party's defenses thereto. Nevertheless, to moot the dispute, oh my god, that rhymed, sorry, concerning this interrogatory by June 13th, which is in a couple of days, the Wayfarer parties will identify the reporters and news or media outlets with whom they have communicated concerning Miss Lively, Mr. Reynolds, the CRD complaint, the actions, or the Lively Reynolds companies from June 15th, 2024 through December 21st, 2024, which is the date on which Miss Lively filed her complaint with the CCRD, alleging she had been subjected to a so-called retaliatory smear campaign. The lively parties improperly seek to expand the scope of this interrogatory to the present because, according to them, Miss Lively's amended complaint alleges that the purported smear campaign is ongoing. Again, I can't believe that people just don't like her or what she's doing or don't believe what she's saying. It has to be an ongoing smear campaign. So that's obviously what's going on here, guys. Okay. However, the amended complaint does not assert any claims by Mr. Reynolds or the Lively Reynolds companies, and therefore the lively parties cannot explain why the Wayfarer parties should be compelled to identify any communications pertaining to them. Moreover, and putting aside that the allegations of an ongoing smear campaign are made on information and belief, the pleading cites to the communications at issue. Identification of content creators. Let's see. Lastly, the lively parties demand that the Wayfarer parties identify all content creators with whom you have communicated in any manner concerning Miss Lively, Mr. Reynolds, the CRD complaint, the actions, and the Lively Reynolds company, or the digital campaign from May 1st to present, which is a lot. If they actually did what they're, assuming, which I don't think they did. Okay. According to the lively parties, they are willing to narrow the term content creators to mean any individual or entity who seeds, generates, creates, or influences social media content or provides related digital or social media services directly or indirectly at the request of or on behalf of any Wayfarer party or their agents or affiliates. Regardless of the lively party's attempt to salvage this interrogatory, it is still hopelessly vague, unduly burdensome, and seeks irrelevant information in violation of Local Civil Rule 33.3a. In this age of social media, virtually everyone within a wide demographic can generate or create online content. I mean, look no further to know that that's true, because I never should have been on the YouTube. So, this just kind of happened. Moreover, as noted above, certain Wayfarer parties necessarily communicated with content creators to promote the film, and such communications have no relevance to the claims and defenses herein. The Wayfarer parties reasonably suggested to the lively parties that this interrogatory should be narrowed to content creators that monetize their original content and have at least 10,000 followers or subscribers, which is a widely recognized benchmark where online users unlock monetization features and begin to attract brand interest. On a single major platform, such as Instagram, TikTok, Facebook, etc. Okay. The lively parties rejected that proposal. The Wayfarer parties further proposed to limit the interrogatory to communications concerning the subject matter of this litigation. In response, and without any further effort, the lively parties filed the motion. Local Civil Rule 33.3a restricts the scope of interrogatories to those seeking names of witnesses with knowledge of information relevant to the subject matter of the action. Lively propounded this interrogatory only to tag Local Civil Rule 33.3a restricts the scope of interrogatories to those seeking names of witnesses with knowledge of information relevant to the subject matter of the action. I think we just said that. This interrogatory violates Local Civil Rule 33.3a. Okay. We respectfully request that the court deny the lively party's motion. Now, look, I have no idea how the judge is going to go on that one. Obviously, I don't think that they should be able to see all those communications when they're not relevant or purportedly not relevant to the ongoing case. So you would make the cut. Yes, I would, but you need to look no further than my absolutely disgusting, hideous Pacer bill, where I buy all these court documents, to know that that is where I get my information. So I have nothing to show, and I seriously doubt that I would be on anybody's radar as such, because like I don't really say anything like out of the box. It's all like court stuff, or stuff that I can show you where I read this or where I got this information. It's not like I'm giving you inside information, really. So it would be pointless to ask me for anything, or to ask them to identify me for any reason. So, all right. I'm curious how much your Pacer bill is. So I've been asked this before, and I don't want to give the number, because I people are going to be like, what the fuck. But just know that when I use Pacer this much, I understand that it's like an investment. Like there's a reason that I do that. I don't like to wait for them to pop up elsewhere. I like to get to them first, and I like to get to everything as quickly as I can. Can we donate it to the Pacer bill? I mean, you can if you want. I'll have one of my mods will post a link to the Venmo in the comments, or it's also in the description of this video. So yeah, you can, but I don't want to say the number, because I don't want people to feel like they have to give me money. Does that make sense? It was my choice. It was my investment. I knew that I was going to have to pay for it. It's not like I expect people to do that. So yeah. Okay. That's all I got for this morning, I think, guys. I got a couple things I'm going to do today. I'm actually going to Omar's office today, so that's going to be fun. But yeah, like I said, I'll put the. Oh, thank you very much, Tiffany. I appreciate that. Like I said, I'll put the link in the comments. You guys are too nice. Hang on. Vilo90, thank you for the 5. Lauren, we love you and appreciate all you do. Also, F Blake Lively, she's a cunt. Yeah, I mean, I don't disagree with that. Thank you very much. Millennial Mom, thank you for the 10 Pacer funds. Thank you very much. I appreciate you guys. All right. Shasti says no one contacted her and she's the poster person for the smear. I agree. I think they're going a little hard on the Shasti Flaw thing, and it's like she didn't really do that for any reason other than this person is coming out and acting like a heinous asshole to Justin Baldoni and Wayfairer, and she's like, "Oh, I have by the way, some footage here that shows what an asshole she could be." So it kind of sounds like it was just something she decided to do on her own. Lily May, thank you for the 15. Pacer Bill, love you for updating us. Well, I love you too. Thank you very much. Always about me. Thank you for the $2. Lauren, you're the best. F the jealous haters. Thank you very much. I appreciate it. All right, guys. I got to take off now because I'm going to Omar's in a couple hours. So thanks. Oh, Kim. What's going on, Kim? I miss you. Thank you for the 5 Pacer books. I appreciate it. All right. Now I really have to go. Bye, everyone.